thank you very, very much for bringing the Better Government Association to the capital city where it belongs. And I understand that Andy has brought a celebrity today as well with him. So Andy, take it away.
So let me begin by introducing you to Watson the watchdog. If you can't see him, stand up. You probably saw him in the reception area. Watson is our mascot. He is going to help us watch government. Watson is a rescued dog from the organization PAWS up in Chicago. It's a no-kill shelter. They found him for us. They helped us come up with a good name for him. They've trained him. They found a permanent home for him. And now he's going to be on loan to us whenever we need him to help spread the word. We envision a full-fledged campaign around Watson with billboards and advertisements in which we use Watson to reach a group of people who may not be easily disposed to paying attention to a watchdog organization. Maybe they'll pay more attention to the watchdog. So with that, he'll be around a little bit afterwards if you want your picture taken with him. Trust me, he'll go viral in moments. I'm gonna hand him off to Mary Frances.
Please follow on Twitter and Instagram.
Oh yeah, he's got a Facebook page, a Twitter handle. He's on Instagram. He's the best known of any of us. Anyway, look. First of all, let me just say how thrilling it is to see a room full of people gathered to listen and hear about a topic that is not the sort of thing that's going to be on the front page of a celebrity magazine. The word FOIA is not inherently hot or sexy, but this room being full tells me that there are plenty of people in Springfield, like everywhere else, who understand how important FOIA is. Let me back off for 1 second. Open collar, because we're talking about open government. So hope you get the symbolism. The Better Government Association, for those of you who are not familiar with it, is a full-service watchdog organization. We investigate, litigate, educate, advocate, and communicate for the better government we all deserve. Why do we do that? Because we're entitled to good government. It's what we should get in exchange for our hard-earned tax dollars. We haven't been getting it in Illinois. We haven't been getting a sufficient amount of it in Chicago or Cook County, and you could argue that you haven't been getting enough of it in many of your local government jurisdictions. Our democracy in many ways has been hijacked by a lot of people, a lot of insiders who've basically turned it into a business for themselves and their friends and their family members rather than a service for taxpayers. And so while we at the Better Government Association respect and love public employees, this is not a Jeremiah against public employees, most of whom give you a day's work for a day's pay, deserve adequate salary and benefits, and should not be demonized and vilified. However, we have a political class in Illinois and all too many jurisdictions that run government for themselves. And that's what has to change, and it has to change by vigilant watchdog work. So we do all these things as a watchdog organization. We do them in partnership with media. One of the reasons we're here today is because we partner with lots of media friends so that we can tell our stories on television, on the radio, and in newspapers. The key to watchdog work is information. You cannot shine a light on government and hold public officials accountable, which is our mantra. You can't do that if you can't see how decisions are made that affect our tax dollars and our lives. Open records are the coin of the realm in seeing how government operates. More than 200 years ago, Patrick Henry, who's probably most famous for saying, "Give me liberty or give me death," also said, in a much less quoted and repeated line, that if we don't have access to information, we will be subject to the whims of the rulers. The rulers, of course, the folks who run government. Every investigation starts with information. It starts with documents. And so the Freedom of Information Act is the critical document that gets us the public records we're entitled to. 6 years ago, Illinois rewrote its FOIA Act and came up with what is regarded as one of the strongest FOIA bills in the country. It is an act that entitles us to almost all public records with a few exemptions, a few legitimate exemptions involving confidentiality, certain labor negotiations and personnel matters, certain things that are rightfully kept under wraps. Unfortunately, since that bill was rewritten, government has been trying to weaken and dilute FOIA by claiming exemptions that don't really exist, by refusing FOIA requests, by increasingly shutting the door on open information. Every legislative session, we fight a battle or two to protect FOIA from further incursions. This very session, there's a bill or two aimed at undermining FOIA in various ways. It's an ongoing battle, and it's really a tough one. It's a tough one for organizations like ours that have the benefit of lawyers, and for the news media that has the benefit of lawyers. Before I let Angie take over and we hear from our panel, I'll just say one last thing. We will never reclaim our government. We will never reclaim our democracy unless we do it collectively. Watchdog organizations cannot do it alone. The news media can't do it alone. A few well-meaning public officials can't do it. We will only get the government we deserve when we collectively try to put the heat on public officials and when we take advantage of the tools at our disposal. FOIA is not just for the BGA and the State Journal Register and Illinois Times and WMAY. FOIA is for every one of you. But many of you are not equipped with the same resources and sophistication that watchdog organizations have. And so this event and other things we do of this nature are designed to not just inform you about the pros and cons, but to arm you with the tools necessary to get the information you deserve. And final word, we understand that FOIA can be onerous, cumbersome, and expensive to government. We get that. The place we disagree is we feel it's a basic obligation of government to take the time and the money and the resources to satisfy FOIA requests. Very often government will argue, well, we're there to do something else. Yes, you're there to do something else, but you're also there to provide the documents that we're entitled to. You can have it both ways, and I think that if the takeaway I hope comes out of this today is that all of you leave here equipped with more information that will enable you to get the documents you need or seek the help you need if you're not getting the cooperation you want from government. We have a great panel, and we're going to have a great conversation. With that, I want to introduce the executive editor of the State Journal Register, one of our main partners here in Springfield, Angie Muse, who's going to lead the panel and take us deep into FOIA land. Angie?
Thank you. It's fitting that we're all here today. We just recently wrapped up Sunshine Week, which is been going on for 10 years now. It's an annual week designed to spotlight the importance of open government and open information. And, you know, I think that it's great to have a week. I would argue that hopefully every week should be Sunshine Week when it comes to government. It's been 100 years since the famous observation that sunshine is the best disinfectant, but I think for a lot of us, we still believe that's very true. I'd like to introduce our panelists today. To my immediate right is Bruce Rushton. He is a staff writer at the Illinois Times. Bruce has worked at newspapers in 4 different states, and among his many awards is the Freedom of Information Award from the Association of Capitol Reporters and Editors, which was bestowed to him for a series that looked at the weaknesses in Illinois' Freedom of Information Act. In the center is Julie Tappendorf. Julie is here on behalf of the Illinois Municipal League. She is currently the village attorney for Gilbert's, Lindenhurst, Wadsworth, and Herrick, and the city attorney for Pana, and is a frequent speaker and expert on freedom of information issues as they pertain to municipalities. And on Julie's right is Matt Topic, who is the BGA's outside counsel. He is an attorney at Lovey & Lovey and has litigated FOI lawsuits, been involved in training residents on how to use FOI themselves, and advises the BGA team on legislation. We thought we would start off by first covering the preamble to the Freedom of Information Act here in Illinois. It says, The General Assembly hereby declares that it is the public policy of the state of Illinois that access by all persons to public records promotes the transparency and accountability of public bodies at all levels of government. It is a fundamental obligation of government to operate openly and provide public records as expediently and efficiently as possible in compliance with this act. The act is not intended to cause an unwarranted invasion of personal privacy, nor to allow the requests of a commercial enterprise to unduly burden public resources or to disrupt the duly undertaken work of any public body, independent of the fulfillment of any of the aforementioned rights of the people to access to information. So I'd like to kick it off for the panel. If each of them could just talk a little bit about what those words in the preamble mean to them in terms of where they're coming from and the groups they represent, and how they feel the spirit of FOIA is being carried out today.
It's not going to be a positive view for me. I think those are just words. I don't think that they have any real meaning. And the reason why I don't think they have any real meaning is the law has no teeth. FOIA is not enforced. It's not enforceable at all. The backlog at the Attorney General's office is proof of this. We are never going to catch up. We are never going to have an effective law unless we have a law with teeth and a law that can be enforced. And there are plenty of examples elsewhere in the country that we can look to for examples on how to have an enforceable law. Florida is one example. Washington State is one example. There are multiple examples of how to have a law with teeth. But until we get a law with teeth, we can have all the words we want, but they'll just be words.
Thank you. Taking it from a different perspective, I do a lot of trainings for Freedom of Information Act and Open Meetings Act, so the sunshine laws, with my municipal and other government clients. And typically on my slide presentation, the first slide to kind of get everybody started is part of the preamble. And I want to introduce to my clients in the training the importance of the spirit of the sunshine laws, which is to promote transparency in government. So I know I'm kind of the lone wolf up here on the government side, but I do want everyone here to know, and Matt and I have talked about this, that from the government side, most of the governments, certainly the clients I work with, are about promoting transparency, are about following FOIA. I know there are plenty of examples out there of bad kind of decision making on one side or the other. But from my perspective, I think it is an important introduction and preamble to the law. And I do think it helps guide for my clients if you're always, and I tell them, if you're always in the back of your mind thinking, how do I respond to this and how do I deal with this particular request or this particular issue, if in the back of your mind it is within the spirit of the law is that I act openly as a government, then you'll make a good decision. So that I think they're good words.
Yeah, I agree. They're very laudable goals. I think they set out the way the government should approach FOIA issues, and they do actually account for some of the other concerns as well, like personal privacy and the potential burden from requests that are too broad or too many or whatever it may be. But I think in practice, I don't see them carried out with quite the level of diligence that I would want to. To Bruce's point, I think I haven't given up hope, and I'm not suggesting Bruce has given up hope.
Yeah, you could never give up hope.
But so I think that the reality is there's the courts have recognized this many times that government will inherently want to operate in secret. It just will. People don't want to have someone looking over their shoulder. I wouldn't, and probably most of us in this room wouldn't. It's counterintuitive to the governing process. It's something that has to really be forced to happen. And there are mechanisms in the law. I mean, there is the Attorney General review. There is litigation. There are ways to go about and enforce compliance when that's what it takes in order to get transparency. But I think we have to sort of recognize that it's something that has to be fought for, or probably always will be something that has to be fought for. And the statute should be about making it as easy as possible for people to get records.
Okay. Bruce, you mentioned specifically the law, in your view, doesn't have enough teeth. And as Andy alluded, laws are constantly in flux. There are always efforts to adapt them, change them, hopefully improve them. Could each of you talk a bit about improvements that you think are needed in the current law?
Yeah, I think we need to get the Attorney General out of the FOIA business. What I have envisioned here is a public-private partnership. The public's part of it would be on the part of the General Assembly to pass a law that is understandable, that is clear, and that has teeth. And then the enforcement part of it should come in the private sector in the form of lawsuits. And if the Attorney General has to be involved with this, then in my view, then governments which throw silly excuses, and they do all the time, because the way that they avoid producing records is they punt to the Attorney General's office and count on the backlog to delay the request. Well, maybe they wouldn't count on that backlog so much if, for example, they had to pay a $500 per day fine if they lost, or a $100 per day fine if they lost. And that's the way there's a handout that I had about Washington State, and that's the way it works in Washington State. And they're per day fines, and they can be very high for governments that don't see the light. It's a scandal in Washington State that in 6 years, the state spent almost $5 million in fines because they didn't follow the law. Think about that. We're spending now 10 attorney generals in the Attorney General office, full-time lawyers. It's a mini law firm, and we're paying the price of that to help government hide records. That's wrong. The government should be paying the price for that law firm that we're now paying for, and the recalcitrant public bodies that don't follow the law should be funding that, not the taxpayer.
Yeah, and I had, on the way here, I was on the train and I was emailing one of my colleagues at another law firm. He represents school districts. And I said, it was just popped into my head, I said, if somebody asked me what would I change about FOIA, and I hadn't given it a lot of thought because it is the law. And so as representing governments, my goal is to advise them. How do you comply with this law? So I hadn't really thought about how it might be better changed, whether it's to make it tougher or to loosen it up in some way to benefit governments or tighten it up to benefit requesters, whatever that was. We live within what it says today. And he kind of said the same thing back. He said, there's really nothing I would change about the law. I might change some of the perceptions of how people view the law and how people view our clients, the governments, and how they comply with it. There have been some changes made. Some would be favorable, some would be not favorable if you're on the government side of things. I think that one of the more recent changes that I find very helpful, and I would think that people in favor of transparency would be as well, was the change that allowed governments to place items and records on their website and refer requesters to the website. I thought that was a good, if you want to call it a compromise, for promoting transparency, which is really what FOIA is. We're not trying to make it, and we shouldn't be trying to make it difficult on governments to comply. So if we can get government bodies to put more information and more records on their website that people can access in an easier way, we've made, in my view, a win-win for both sides. It's easier for the government to not have to look through all these records and make copies and send them out, and it's certainly easier for members of the public to go on the website if they have access. Obviously, there's an exception if you don't, but if they have access to a website, to be able to access that. I thought that was a good recent change to the law that I think everybody can get behind.
So I'll start with that. I agree that I think that what I believe was the intent behind that provision was a good one, which is to say if the government can point to specific records on a website, it shouldn't have to go make copies of those again. But let me tell you what has happened in practice, because it's happened to my own FOIA requests that I've made on the letterhead of a law firm who sues the government all the time. So if it's happening to me, it's happening to other people too, I'm pretty darn sure. I didn't get links to particular documents. I got a link to the Chicago Police Department directive database where I could purportedly conduct my own search to go find my own records. That's not what this is supposed to be about. It's supposed to be about specific records, providing specific records through the internet, not requiring the requester to try to figure out and understand government records and figure out well, which is the policy that applies to this particular situation? That's a fundamental thing that people always ought to be able to get immediately. I want to know what's the policy that governs this situation. That should be the prime records for a government to produce. I shouldn't have to go search a database to figure out myself which ones those are. So, I mean, I think in terms of, by way of context of, anytime we talk about what should be changed about the law, I think a lot of times what happens is there may be good intentions or particular intentions, and there's bad drafting in the way that the bills actually get written in a way that doesn't have the intent. And so the fundamental, I think, problem with that is a lot of these things go way too fast. They get introduced. I mean, we at BGA, fought back a bill that was introduced over Thanksgiving weekend and fast tracked to be done in like a few days. Like that's, I mean, the irony of that when we're talking about a transparency law, that the process of amending it is not at all transparent. That's a big part of the problem, is that we need to have a slower, more methodical process. And if we're going to talk about how we should change the law, I think we need to start by looking at what's really happening, because you will hear stories about government bodies that go completely off the deep end and hide records, destroy records, do stuff like that. And then you'll hear stories about, requesters who are harassing, who make huge requests for lots of stuff because it's just out of spite. Well, I think what we need to do is we have a body of thousands and thousands of public access counselor decisions. I think that's a great microcosm for what's actually happening on the ground. And we need to start by looking at that and saying, can we see some trends here? Are there particular exemptions that are getting overused and overasserted, where the Attorney General has rightfully found that 95%, and I'm not saying this is a statistic, but it wouldn't surprise me, if 90% of the time the deliberative process exemption was asserted, it was improperly asserted. Then we really need to look and say, maybe we should just get rid of that exemption. Because if the vast majority of the time it's being abused, then is it really worth is the game really worth the candle over that exemption?
If I could interject for a second.
Yeah.
I mean, you talk about thousands of opinions. Since these reforms took effect, there's been exactly 46 binding opinions that have been issued by the Attorney General's office. And most of these, if you go back and look at them, they're simple ones. I mean, time and time again, it's duty to respond to FOIA requests. These
Yes.
public bodies are simply not responding to FOIA requests, and it's often the same public bodies. Not only are they not responding to FOIA requests, when the Attorney General calls them, they're not responding to the Attorney General. And nothing happens to these public bodies that do this. They pay no penalty. I'll give you one other real-life example. This isn't just outliers. I have a pending FOIA request now, not to the city of Harvey or the village of Wapella. This is to large state agencies. My tipster says, hey, these guys, gentlemen, who are state employees, stole from the government. They stole a whole bunch of, because I'm competitive situation, they stole a whole bunch of widgets. And they got, I don't think that they got punished enough. They got a tap on the wrist. Fine. So I issue FOIA requests to the two agencies that are in question here. I say, I want to know that if this in fact happened, I want to know what happened to these employees. I got nothing, not a single slip of paper. They threw something like 8 different FOIA exemptions at me and said, I have no right as a citizen of the state of Illinois to know what happened to folks who stole government property. When that is the situation, we have a real issue here. And this, again, is not an outlying agency. This is big agencies in the state of Illinois.
Well, I'd like to build off of what Matt said on just the PAC opinions, and we all know who the PAC is. That's the agency as part of the Attorney General that's in charge of enforcing open meetings and FOIA. So if you don't go to court, that's where you go if you have an appeal of a decision of a government body. And I do a lot of PAC work, so a lot of requests for review come to me when it comes in as the, okay, government, now it's your turn to respond. There are, as you said, 40-plus binding opinions in the past 5 years from the PAC office. There are thousands, I believe, advisory opinions. For any of my clients, I've never gotten a binding opinion from a decision. Every decision that my clients have gotten from an appeal of one of their decisions has been advisory. I find those actually very helpful. They're not the law. There's not the force of law that a case or maybe a binding opinion has, but they do provide a lot of guidance to my clients. So I have any number of advisory opinions that I can use to say to another client, hey, this is how the PAC is interpreting this particular exemption, whether it's deliberative process or some other exemption. So don't do that, or make sure that you're in compliance, because if you, even though it's not binding, if you get an appeal, it's going to go to the PAC, and this is what's going to happen. Unfortunately, it's really hard to find these advisory opinions unless you FOIA the Attorney General's office to get them.
And they're behind too.
And right, and they're behind, just like a lot of governments. It's very difficult. That's a lot of advisory opinions. So, from and this is kind of my help governments comply, give them the tools. It would be helpful to have those opinions online. You can easily find the binding opinions if you go to the Attorney General's website, but the advisory ones are nowhere to be found. I think cataloging them, summarizing, however that is, so that we, the governments, those that represent governments, have that advice. There's not a lot of FOIA cases. I mean, except for the ones that Matt's involved in. There's not a lot of cases for those of us that represent governments to have some help in how we interpret what can be a somewhat confusing list of exemptions and procedures. So these PAC opinions, these advisory opinions, I think would be very helpful for the agency in charge of transparency to post those and have those available.
I think you underscore. Oh, go ahead. I'm sorry.
Oh, yeah, I was just going to follow up on a point there, which is that I think that actually sort of illustrates what, in practice, I think a lot of the problem is. It's an incredibly simple statute. It says that the government has to prove an exemption by clear and convincing evidence, and there's a presumption that every record is open. So that means if I'm the FOIA officer, if it's not crystal clear to me, completely obvious to me from reading the statute that the record's exempt, then I ought to be producing that document. And I think that's a big part of the problem, is that there's a belief that we have to get to, opinions or court cases to interpret pretty plain language. And there's, I think just it's getting lost that there's a presumption that the record has to be produced. So if you don't know, if there's any doubt in your mind as a FOIA officer as to whether the record should be produced, you should just produce the record. There's a built-in mechanism that makes it incredibly simple. The other thing I think is, I think a lot of public bodies don't realize that rarely are they required to assert an exemption. Right, so there's laws like HIPAA, or there's certain things that could bar the production. You'd actually be violating a law to produce a record, but that rarely is the case. And so when you couple that together with the presumption of openness, it's really just, it should be very simple, but it isn't. And I think the reason it isn't is because people are afraid that, rightfully or wrongfully, that you may have people that are actively trying to hide wrongdoing, and you may have people that feel like, well, if the press isn't going to give me a fair shake, or I'm not going to be heard, or so it's easier to try to just control the information and not.
I'm going to disagree with you. I don't think it's an incredibly simple statute, and I think that's part of one of the problems. Because if it was an incredibly simple statute, we wouldn't need 15 full-time lawyers at the Attorney General's office trying to interpret it. The list of exemptions is long. They're sometimes self-contradictory. For example, one part of the law says information bearing on the public duties of public employees shall not be considered an invasion of privacy. Seems pretty simple, right? Except for another part of the law outside FOIA says, well, you can't have performance evaluations because those are private. That just doesn't make any sense to me. We have the deliberative process. If you're speaking of 7.1F here, that's the most problematic exemption in the entire statute. It's been known for years that this is problematic, and this is the one that says unless it's final, you can't have access to it. And it makes a certain amount of sense, and all states have some variation of this. But in Illinois, it's taken, in my opinion, way too far. The governing case law was a Boeing case under Governor Ryan, where the state paid for a consultant to produce a report on the merits of paying out public money to entice Boeing to come to Illinois. And so the consultant was paid, but the report was secret and remained secret because it was deemed to be a preliminary document, even though we wrote a check for it. That's crazy. That is just nuts that we paid tax money to a consultant to produce a report that we're not allowed to see. And when you have that sort of an issue come up time and time again, it's time to revisit the law, simplify the law, and put some teeth into it.
Matt, you had mentioned earlier the experience of requesting something and being told, well, it's on the website, and being sent to essentially a database to unearth the document yourself. Can the two of you weigh in on whether you have encountered that yet? And, what's behind that? Is it just not being familiar with what's required, or did you feel it was a deliberate attempt to thwart you?
I think that the statute the language is not sufficiently, so here I just said it's a simple statute, now I'm going to tell you that in this instance, it wasn't so simple. And just back to that point, what I mean is, if in any instance there's not a simple answer, then there is a simple answer because it defaults to production. That was really the point I was trying to make. What was I saying? The website.
Yeah.
I think it turns on the phrase reasonably accessible. And is it reasonably accessible to me if I have to go search for the record and then try to figure out, is this really the record that governs or not? So that was, I think I think that's language that can and should and hopefully will be improved to make clear, if the government produces the specific URLs to those records, then by all means, then great, put it up there.
And that's what I would advise a client. So if I had and I have advised my clients, put everything on the website. There's no argument if it's there. If somebody filed a FOIA request and said, I want a copy of the meeting minutes from November 2012, and the client has all of their meeting minutes on the website, then send them the URL or send them the link. If it's a downloadable document, sometimes you can't send the URL to that particular link, but you can send them a URL to the page where all the meeting minutes are. Something along those lines, that the more specific the government is, and I tell them, don't make it harder on yourselves, because you have a great law. So comply with it, make it easier on the requester, which makes it easier on you. Because otherwise you're gonna get in these guys, kind of sight, and then you're the bad government. So don't make it bad for everybody else. And it is, from just a general management of resources, it is a significant amount of work for my clients, the village clerks, the township clerks, many of whom are part-time. Some of these communities are very small, and they may spend, especially in what we call the silly season, the political season, they may spend all of their time on responding to FOIA requests. I mean, this may be a significant amount of their time. So if we can make it easier on them from a legal perspective, from the legislation, to say, it's okay for you not to have to copy every single meeting minute for the last 4 years now, because they're on your website and you can refer them, and here's the URL, then more power to you, clerk, because now you can get back to your other duties, and the requester can get the records, right? So that's what we're trying to do. So I think from a legislative perspective, anything that we can do to give the clerks and the other people more time to do their other duties and still provide the records, let's do that. If simplification of the law, we want to talk about recurrent requester and voluminous request. I think those were, in theory, really good for government. This was a way to try to address some people. Government's getting inundated with FOIA requests by the same people every day to harass. And you may not, anyone in this room may not be involved in that, but I know in some of my communities that the FOIA requests had very little to do with the actual documents and much more to do, and this is the exception, of course, with harassing the government officials. And we have this law, we have a recurrent request, we have unduly burdensome, and we have voluminous, and trying to fit within. If you haven't tried to apply that law, in most recently the voluminous request, trying to understand what the interpretation and the definition of voluminous request and the process that the government has to do to follow it. And I was trying to talk a village clerk through this. Okay, so it fits within voluminous request because it was 50 documents or requests, or it was 5 million pages, whatever it was, it fit within it. So first you have to send them a notice, and then within 7 days you have to do this, and then you have to do that. And finally I said, why don't you call the person and see if they'll narrow their request? Yeah. We went back to the old, because it was, it made what could have been better actually made it much more complicated, which happens with legislation.
I'd like to get back to the voluminous requests in a minute, because I'm sure Bruce and Matt may have a different take on it. But before we move on, Bruce, the issue with the government pointing people, it's online, but Where is it? Have you personally encountered that yet?
Well,
as
no,
a-
I mean, I haven't really encountered that yet, and frankly, I think that's kind of a shiny little balloon to take the attention off where it really deserves to be. You know, the stuff like the meeting minutes, I don't mean to go back to the topic again, but the topic, see, the things that you're describing, these are outliers. I mean, there's, what, 7,500 public bodies in the state of Illinois? We're talking about a handful which have those sorts of issues. You're the municipal league, you have dues, I mean, you know, figure it out yourself, and if you have to, like, take up a collection to send the shock troops into Wapella or whatever little village is having these little squabbles, then do that. But don't hold the rest of the state hostage to the abuses that are happening in just a handful of places. That's what's happening here, is everybody pulls these things. Well, you know, I know about this little clerk over in the village of Acme or wherever it happens to be where this terrible thing happens. But forgetting about what's happening at CMS, what's happening in the state police, what's happening in large government agencies that are consistently refusing to produce requests, looking for excuses, looking for loopholes, and finding them. That's what the problem is.
Yeah. So the voluminous request law, which was one that the legislature passed last year, vetoed by Governor Quinn, overridden by the legislature. In disclosure, the SJR editorial is a very bad idea. What has been, we can agree on things, Bruce.
No, you're right.
But in your experience, Julie, you've touched on it from the provider standpoint. What percentage of requests, from your perspective, at the municipal level, how common is it really a problem that it's a harassing type thing?
Very small. And I would say on both sides. So if we're looking at the problem requesters and the problem governments, and it sounds like you've had a different experience, but in my experience, we represent at my firm a lot of governments, and very few of them, if any, are the problem municipalities that just don't respond to FOIAs. I mean, I hope not. I hope we've trained them better than that. That it's a small minority that then requires a whole change in law, and it's a very small group of requesters that are these voluminous or recurrent kind of requesters. And again, I'm not talking about people requesting documents because they're interested in a referendum or they're interested in a particular issue. They have the right to those documents. And I explain to my clients, yes, they're asking for a lot of information, but that's information that they're entitled to have. It gets very different maybe in an election, or maybe when you have somebody in the community that's just kind of opposed to everything, when it is used as a tool of harassment. It is very rare, but I have a couple of clients that have dealt with it. So it's the same people, and it's very clear that the requests, and they don't pick up the documents.
Yeah.
They don't care. They don't, you know, it's not about the documents. It's about making somebody's life or many people's lives miserable. Do we need to change the law for them? Maybe not. Do we need to change the law for a couple of bad governments? Maybe not. I mean, it's kind of on both sides that we spend a lot of time talking about the outliers because they're the visible.
Yeah.
And sometimes we get away from most governments want to comply, and most requesters just want documents.
And
Matt
as
and
far-
Bruce, what's your experience been with the new law?
Voluminous isn't necessarily bad. I mean, sometimes you need a lot of information to draw certain conclusions about things. And I would point to a really excellent series that Chicago Tribune recently did on problems in DCFS. Talk about voluminous information. I mean, they went through thousands upon thousands of records to produce a series that really has made a difference, and it's caused some change that was really needed in this state to help our most vulnerable citizens, our children. Are we going to say, well, you know, that's a voluminous request, we really shouldn't have to comply with that? And, you know, it's not just, you know, these smaller governments. Chicago Public Schools has a terrible record in terms of complying with FOIA requests if you look at the binding opinions on the Public Access Counselor's page. They just ignore them. And they've been caught doing that more than once. And so, again, you know, there's no downside to ignoring it. There's no downside to ignoring the Attorney General. And if a public body chooses to fight a binding opinion by the Attorney General, guess who has to enter the lawsuit? The person who requested the information to begin with. You are now a party to a lawsuit that you didn't want to have happen in the first place, which is why you went to the Attorney General to begin with.
So I've heard this idea of sort of harassing requesters. I know that was, I believe, part of what was used to justify this voluminous requester bill. But I've yet to hear any facts about who those people are, what they did, or how it became so clear that they were only making requests to harass. Because I think a lot of it is a matter of perspective. And if you're the current elected official and you're dealing with somebody who comes out to all your board meetings and makes a lot of public comments and is very openly critical and maybe is even very loud and obnoxious and difficult in a way that really kind of keeps with, in some ways, the best parts of American democracy, that it is a loud process. There's nothing wrong with that. And I fear that I don't know how real these examples are of quote unquote harassment or how it's being shown that they really are harassment. And I think a lot of it has to do with what the perspective is. And I suppose there's some of that the other direction too, that not every time that the government fails to comply with FOIA, it's because they mean ill or because they want to make trouble or because they want to actually hide something. But I think when it comes to, and I do agree that to some extent that you can't just look at the outliers and say, you know, we should make fundamental changes to the statute because of the outliers. But I think that to the extent that's happened of late, it's happened in a way that has restricted public access and not broadened it. I mean, we have a civil penalty provision. So there are, I mean, to some extent there are teeth. If you go to litigation, it's all of $2,500 to $5,000 if you can prove that it's a willful and intentional violation. And we have, I think, all of one case.
One case, exactly
that's actually ruled on that so far, right? So that's not really that. I mean, that isn't really a disincentive. I mean, that's nothing. That's the attorney's fees are going to be more than that. So that's kind of a small piece. But I think that, you know, there are plenty of examples I can just say from my own experience of public bodies failing to respond to requests. I mean, I have multiple suits against different City of Chicago agencies on that, just flat out ignoring requests. Or just, you know, really tenuous exemption claims. We've gone afield from the question, which I think was about voluminous requests.
Yeah, not to interject, but that's exactly why these changes were implemented back into 2010. The problem then that was stated was that agencies don't take FOIA seriously and they ignore FOIA requests. We're right back where we started. And one question I had for Julie, I mean, I'm just curious because the Attorney General does training. You're required, if you're the FOIA officer for a public body, to undergo annual FOIA training. And yet the Municipal League apparently has to have training too. I mean, is it the question of the law is too complex? I mean, what is there a lack of training? The Attorney General, if the Attorney General is doing the training, why do these folks have to be trained twice?
Yeah, and I can't speak for all governments. I do FOIA training for our clients when they request it. I train at the Municipal League. We do FOIA trainings at the conference. I do them at library conferences, park district conferences. I'll go out, and if a client just has questions about it, sometimes we'll get clients together, the FOIA officers together to do a FOIA training. I can't say that more training is bad. We're all training on the same law, so you know, we sort of got it's very simple and it's very complex, and somewhere in between I think is probably where the law is. There are parts of the law that seem very clear to me, you know, whether it's how much you can charge for a document, how much time you have to respond to a request, and you know, there are a lot of exemptions. For the most part, they're, I think, fairly clear. Again, if you don't know, I wouldn't say give the record out, because somebody may not know that there are particular statutes protecting health documents or juvenile records. They might check with their attorney. They might check with somebody that's been trained on FOIA before they release the document. You know, if there's a question about one of the other exemptions, there are very few exemptions that are what I would consider mandatory, as you said. Otherwise, and I've told my clients this, that unless it's a mandatory exemption, and that's a different law, like HIPAA, you can choose to give out the records. You don't have to take the exemption. And sometimes they do.
Really?
Even if an exemption. Yeah. See, I don't represent the City of Chicago, so I may work up there, but I don't represent them.
Yeah, so the thing is a bit of a corollary to this is I'm surprised how often, whether it's for BGA or someone else, I file a lawsuit to get records. We drag it out. You know, there's costs, there's delays, yada yada yada, and then we win, and then we get the records. And the records could not be more innocuous.
Yeah.
I mean, it's sort of what's all this fighting over? And I get it, you know, from time to time, maybe there's like, you know, we don't want to set the precedent that this kind of, which is, I mean, it really isn't precedent. But I'm just shocked how often there's just there's just nothing there, and public bodies that even hire private attorneys running up substantial bills, and then if they lose, then they're on the hook for the requester's attorney's fees. I mean, lots and lots of money at stake over things that were just so silly to even be fighting over, and that really makes I always scratch my head at that, because it seems to imply to me that there is the resistance to transparency is so ingrained that even when the common sense looking at a particular record is not even there, it just becomes like, well, I have a decent argument to withhold this, so I'm going to withhold it.
That is exactly
how it feels
right
to me, and I don't know that firsthand because I'm not a FOIA officer, and I haven't, no FOIA officers have told me that, but at least it feels that way.
You look at Ferguson for a second, what's happened over there, and some of the emails that were exchanged that were exposed in the Department of Justice report. You couldn't get those in Illinois. They were exempt from disclosure. Folks saying racist things about the citizens that they're supposed to police, those would be exempt from disclosure in the state of Illinois because they would be labeled as opinions. That's astounding, and you should really stop and think about that. And I agree with you. I mean, you get to the end of a fight, and it's like, what were you guys fighting over? It's just this ingrained, knee-jerk stuff that we have to have secrecy for secrecy's sake. And I wish that more folks would do as I hope you do, say, you know what, unless it's FERPA, unless it's HIPAA, unless there's some bright line prohibition, a juvenile record, turn it over. Because there is no downside to doing that. Well, there's no upside. What I'm saying is, I wish we had a state where folks would say, I better turn that over because if I don't, I could get in trouble. And we have exactly the opposite situation right now.
Well, it's I look at it two ways. One is the legal. So we have a list of I don't know, 24 exemptions under Section 7. We've got the exemptions under 7.5 that are mostly the statutory exemptions. That's the legal. So if an exemption applies, then the law says that you can withhold the record. So for whatever reason, whether you're it's HIPAA protected, whether it is a performance evaluation, whether it falls within some privacy rights or invasion of privacy, that you as the government body have the right to withhold it under the law. That's the legislature that made that choice. So we have to fall within the law until that's changed. Now, the policy side of it is, unless it's one of the statutory mandatory exemptions, you don't have to use the exemption. There may be good reasons to use it. If you're in the middle of negotiating a purchase of property or negotiating a settlement in litigation, and you haven't gotten to that point, you could lose any sort of government side advantage by leaking all of this information until there's a final deal, until you finally purchase the property or whatever it is. And there's a reason for certain exemptions. And my legal side would say there's a valid exemption, and the policy side would say there's a good reason to use the exemption in this particular situation. Mm-hmm. If it's a final document and it's been approved and paid for, it's done. It's open. It's releasable, right? I mean, this isn't a draft document. This isn't subject to negotiation. So I think some of it is application of the law, understanding what the law says, applying it, and that's where I think the cases and the PAC opinions are so important. How is this going to be viewed in the court? How is the PAC going to look at this? Let's make sure that if we're interpreting this particular law, that we're interpreting it in the right way. So while I understand your view, everything should be open, there are some reasons, there are some, we are taxpayers, this is taxpayer money, not to pay more for a particular piece of property because the other side knows, the negotiating tools, because ultimately it's going to come out of our pocket.
Well, I would agree with that, but what I'm saying here is that even after the property is purchased, you still can't get it. I mean,
that's a problem.
That is a problem. And so, of course nobody wants to game the negotiations, and I'd be the last one to say we should do that. But after the property deal is said and done, we still can't see it, and that's an issue.
Matt,
So can I
sure, go ahead.
add one? Because something actually just really kind of occurred to me that sort of, I think, could marry together the idea of the policy side and the legal side. And this is something that I think in federal Congress has been bandied about for particular exemptions, but I would propose might be the way to sort of cut to the chase on all this. For all the exemptions, there should be an additional showing the government has to show, which is a demonstrable harm that would come from producing that specific record. Because a lot of time, I mean, there are general ideas behind exemptions that would often apply to that category of record, but it really depends on the circumstances and the exact record. And if the government can't show a demonstrable harm from releasing certain records, then it shouldn't be withheld, even if it technically meets whatever the generalized requirements are. And I think that would bring together the idea of there's what the law allows, and then there's just sort of the common sense of, like, does this really matter? And I would submit that that might really cut to the chase.
That's a really good idea, actually.
Yeah.
Julie, do you agree? No, I'm sorry. That's unfair. It's totally.
Any friendly folks out there?
One of the things,
Gary?
we're throwing the word record around a lot, but with the increasing digital world and the changes, that definition is expanding. Texting, digital databases. Has the law kept up in terms of addressing those types of communications and providing access to that?
I think it's a question for Hillary Clinton. I mean,
Yeah, Hillary Clinton's email server.
yeah, I mean, that's a perfect example of it, you know, and I say this really not facetiously. I'm kind of a mind that before the city council goes to the dais, they should go through metal detectors, because, you know, you can see them up there sometimes and you kind of know what they're, you know, and so call me suspicious, but, you know, I would like to see the public's business conducted in public, and this is kind of a bit aside. We're getting into the Open Meetings Act area, but yeah, if you're texting another council member during a session, you're darn right that should be disclosable. And there is a PAC decision on point on that, I believe, in the city of Champaign.
That's a case.
That's the case.
Call
Yeah.
court decision.
And that, I mean, that's a good point, because the PAC opinion on that, and that was city council members in Champaign texting during the
Right.
meeting, was the exact situation. And that was challenged. I think it might have been a reporter that requested the
reporter, right.
records, knowing that they were texting during the meeting. The PAC had, in my view, and in the government sense, had gone a little far afield in the opinion, and it was narrowed somewhat by the court. The PAC had said that it doesn't matter what device you're using to text or to email. If it's public business, it is releasable under FOIA. The problem for government is that FOIA applies to public bodies, not to members of public bodies. The court, when they got the appeal, said, you know, we don't apply FOIA to an individual. So a member of a public body is not FOIA-able. You can't just FOIA the mayor. But if the mayor is sitting at a public meeting that's noticed to the public and during the council session and is texting another council member, they're acting as a public body. So at that point, that record is releasable. And I think that's a fair, if you want to call it a compromise, or a fair decision to say that first I would tell my clients don't, because that's an open meetings issue. Even if it's a note, the public doesn't have access to the text. Don't text during a meeting. Don't text to a majority of a quorum. So I wouldn't do that anyway. But if they are and they're in a meeting, then the court says that record is a public record. It fits under FOIA and you can get that record. Email, same thing. So to answer your question, I think there's built-in language in FOIA that talks about that. It even talks about that as technology advances, that we're not limiting the language of FOIA just to, you know, it could be social media.
Right.
You know, if you're on Facebook, you know, if you're having a conversation on Facebook, it could be open meetings issue, it could be a FOIA issue. That's a record. If it discusses public business, if it's, you know, in the control or possession of the public body, then that's certainly an issue.
I know
Matt,
we're
your
getting
perspective?
close on time, I think, right?
Yeah.
So I wanted to jump in. So yeah, the statute already has a broad definition of record. It's regardless of physical form or characteristics. So we're pretty well set on that. I think you're both of your points on use of private devices is a really big issue that needs to get resolved. By the way, I think there's a difference. The Champaign case really turns on the fact that it was a legislative body. If you were talking about executive branch officers, I think it's a completely different issue. I think the individual emails of each individual executive branch officer are clearly going to be public records. I think what we need to do, and especially in light of the Hillary Clinton debacle, is there needs to be a law that says if you are a public official, you may not use anything other than a government-issued device to transact public business, so that we can ensure that all of these things are being properly preserved, and that if there's a FOIA request for the records, that the public can get access to it. And if you do that, and then you could have a corollary that says, if you use your private device, you agree that you will provide it to the government on demand, and you will not delete it without express permission of the government. And that that will catch the law up to the fact that people are sometimes using private devices, either innocently or in a deliberate effort to try to keep records out of the public domain.
And you would enforce that how?
You would enforce it the way you would. You would enforce it the same as everything else. I mean, well, you could put criminal liability for using a device that you're not supposed to be using it for, especially if there's a pattern of it.
And there's never been anybody prosecuted in the state of Illinois for criminally, even though those statutes exist. It's a felony to violate the Open Meetings Act. Nobody's ever been prosecuted.
Well, then what you end up with is a very clear directive that those records are subject to FOIA, which at the end of the day, I think is the most important thing.
Okay. Really quickly, because we are running out of time, and we want to have a chance for our audience to ask you questions as well. On the subject of commercial FOIA requests, Julie, what impact do you see commercial requests having on the workload of FOIA officers? And are there ways to streamline the process, to minimize that?
Yeah, before 2010 and the amendments, when one of my clients would get a commercial request, let's say you have a pool, and so you have to get a pool permit. And my clients would get a FOIA request for all of the names and addresses of people that have pool permits, so that then they could sell them pool equipment. Those sorts of things. Back before 2010, those went into the same stack of FOIA requests that you had 7 days to respond to, as it is for the resident that wants copies of ordinances and agreements, and people that, the newspaper wants copies to do a story. There was the change to give governments more time to respond to commercial. I think that's very helpful. If you read the preamble again, it's really not about us as taxpayers paying for governments to help businesses make money, and it shouldn't be. That's not what FOIA is for. That's not what open government means. Governments are not in the business to help people further their business, whatever it is, marketing, that sort of thing. We get requests from vendors for information about our contracts. Those sorts of things. I don't know that I would recommend completely eliminating commercial requests. I think I'd probably get booed out of this room and maybe from other people. But I do appreciate, at least, that they have more time to respond. They can focus on maybe what I think is more important, which is providing records to the people that are looking for transparency in government and to be more informed.
Bruce and Matt, do you feel that the current situation is adequate, or would you make changes?
I would change it. Personally, I don't think there should be any distinguishing. The law should not distinguish between, in my view, commercial requesters, private citizens, and the media. Unfortunately, the law does. There's kind of a three-tier thing. The media is treated differently than plain old Joes on the street, and commercial interests are treated differently than either the media or plain Joes on the street. And in a perfect world, we would all be treated the same. We are, after all human.
Well, I'm sort of torn on this because I don't agree with the notion that government shouldn't be effectively helping business to do business. I mean, that is something the government should be doing. Those are companies that are creating jobs and they're paying taxes, and if they can use government records to create more jobs and generate more taxes, then the government ought to be assisting with that. But at the same time, those requests can be more cumbersome to deal with. There could be a lot of records. And I think it's fair to say if people are making money from the information they're getting from government, it's not unreasonable to say you should have to pay the cost associated with doing that. I don't think that's unreasonable. So I think I don't have any major issues with the commercial request provision. I think it strikes probably a pretty good balance. That said, I'm not, I don't deal with a lot of commercial requests, so there might be more issues I'm not seeing. But.
Okay. We have about just a few minutes left, so maybe if each of our panel could just very quickly sum up anything that we haven't touched on yet today or any parting thoughts for the audience. Matt, want to start?
Sure. So thanks for the opportunity to be here. This is an issue I care a lot about, BGA cares a lot about, a lot of people care a lot about. I think there's a lot of room for the statute to be improved, for it to be modernized. I think the way that that's going to happen is, I think reasonable minds on all sides need to prevail. We need to get away from sort of anecdotal, hyperbolic types of ways of looking at things and really start to dig into the actual data of what has been going on with FOIA requests. We have this huge pool of information from the Attorney General that I think really ought to be the starting point to look and say what really are the issues and what should be done to modernize, make things easier. I'll say too that there are many times when I'm very happy and impressed with the way that government bodies have responded to FOIA requests. My requests, my clients' requests, places that really go above and beyond even what they have to do. And I think, we do try to highlight that when that happens. It's unfortunate that I think there is at least some public bodies that are sort of the bad apples, and we might have disagreements about how widespread that is. But I think it shouldn't be lost that there are a lot of public bodies that really do it the right way. And just myself, and I'm sure BGA as well, really appreciates when that happens. So that's it.
Took my thunder. And I appreciate when, both sides, if we have to say there are sides, but that everybody can recognize what the spirit of the law is, that we do and should work together. I would say, my clients, most of the clerks and other FOIA officers I work with do go above and beyond. And it isn't about waiting 5 days to provide or take the exemption or take the extension because it's by right, and well, I can take the 5 days. That almost, every request that's brought in is processed, in fact, in many times immediately. Somebody comes in with a request and my clerks make a copy and hand it to them. There's no charge. There's no, we got to fill out a form, we got to take an extension. That's my experience with most. Not all, and certainly, and not all the requests are easily fulfilled, and some of them ask for 10,000 records. I've had to look through 10, 12,000 emails to redact and figure out what it is that's protected. It's attorney-client privilege, or it's talking about some litigation or personnel issue that's not resolved. It costs a lot of money. It's time-consuming. It's part of the compliance with the law. So I would say on the requester side, smile, be nice to your clerks. They do want to help you. If you don't need it in 5 days, and I've had this happen too with requesters, listen, I know this is a lot of documents. I don't need it for two weeks. And the clerk will call me and say, oh, so nice, and I'm going to go above and beyond. It works that way on both sides. So.
I would first off say that I don't think the BGA, certainly not myself, we don't think that the government doors should be open to see anything and everything. That's not what this is about, nor is what this should be about. What we're talking about is reasonable access, and a lot of government bodies are pretty good, but there's just too many that aren't very good, and that's what the problem is right now. Again, we're not trying to let out any secrets with lawsuits. We're not trying to reveal your Social Security number, your birthday, your pant size. We don't care about that sort of stuff, but we do care about the stuff that really does have a bearing on how government does its business and how it governs the governed. And so we have a long way to go, and we'll keep trying.
Okay. Let's thank our panel for an excellent discussion. Thank you to the BGA for hosting this event, and thank you to all of you for caring enough to be here tonight.